of cereal stuff in a
Well, a lot
tobacco
of, I
device,
don't,
right? I believe it's the intent of this whole thing is the liquid and the health effects of the liquid being manufactured in China versus made in America. The health and safety code, right? It's not an espionage code.
right. B134.
And so, of course, the device is made in China, like China and Taiwan, and where else could you get? But do you think there's any of these things that are made in America that's made?
That is wholly or partially manufactured in or marketed as being manufactured.
What is that? So that's what I'm,
Is
what is that?
39 days.
A person commits an offense if the person markets, advertises, sells, offers for sale, or causes to be sold an e-cigarette product that is wholly or partially manufactured in or marketed as being manufactured in China.
It's broad. I believe the legislative intent was for the liquid, but the way it's written, I understand it's broad.
All right. I'm going to find probable cause, but I'm not going to put any conditions. Just be careful.
Absolutely.
So I will find probable cause, but just be careful. You know now that it's,
You see, if we're struggling to get caught up to speed here, as two lawyers and a judge, I mean, just a small business owner is crazy.
I get it.
And so it just, first of all, it should be enforced civilly, but the law was written as a written civilly. And I come in and just say, hey, all computer, those are in violation of coming back on.
Look it up. Look it up. Perhaps there's a law that says, I don't know,
Yeah,
do a deeper dive.
give them a heads up.
I mean, normal course.
Right. Should be reasonableness in it.
Like I said, I'm not going to put any conditions. Just be careful. Do not pick up any new cases, really. Because you have a lawyer, I will waive your appearance. You don't have to waste your time coming to court. Just stay in touch with Mr. Burns and he'll tell you if and when.
Zero issues.
Yeah, you're good. Don't worry. All right, thanks.
All right, Judge, council's approaching for top of 23. Villarreal, someone up and sign, please.
I couldn't find that. Couldn't find.
I know, so I struggled with it and I talked to Cam today and then I was able to find the statute itself on that government website instead. It's different.
All right, good morning, Mr. Villarreal. Sir, you're charged with discharging a firearm in a metropolitan area. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. Good morning, Mr. Newley.
Good morning, Your Honor. How are you today?
On May 9th in Harris County, officers dispatched in reference to complainant said that she woke up and found a bullet hole on the door hinge to her bedroom bathroom, along with a hole in the north wall of the bathroom. Complaining witness picked up a bullet jacketing from the floor and hinge. Complaining witness believes the discharge came from her neighbor due to the trajectory of the bullet hole. Officer observed a bullet hole on the north side of the complainant's residence and a hole in the south side window of the defendant's residence. Officer made contact with the defendant, the neighbor, who stated that he had recently purchased the rifle and did not know how to properly use it. Defendant stated that he was performing maintenance on the rifle when he accidentally pulled the trigger, which discharged around into the south side of his room. He stated he tried to check on his neighbor, but could not contact her until she answered a call via Facebook Messenger, and the defendant admitted to the didn't say guilt, Judge.
Okay. Mr. Villarreal, I'm going to find that there's probable cause to go forward with your case. Have you been watching the news? A couple days ago, the same thing happened and an older lady in the kitchen died as a result. And now dude is charged with what? Manslaughter upstairs? No weapons. Do you understand? If I find that you have a weapon, I'm going to put you in jail and I'm going to make your bond high. Do not have any weapons, possession, care, custody, or control. Do you understand? Do you, yes or no? All right, we're going to have you sign a reset. I'm going to have you take a seat in the jury box so we get your bond conditions. Once you sign them, at that point, you'll be free to go. Thank you, Ms. Newell.
All right, Judge, bottom of 11, Hernandez, come on up.
Just no weapons, Judge.
Yeah.
You need to take them out. You can walk straight up. Okay, got it. Thanks.
I'm sorry, you said.
Hernandez on 11.
Good morning, Mr. Hernandez. Sir, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 9th in Harris County, around 8 in the morning, officer conducted a traffic stop on a motor vehicle going 93 in a 65-mile-an-hour zone. The defendant, the driver, had bloodshot, glossy eyes, slurred speech, and a strong odor of alcoholic beverage from his breath. The defendant advised he had 2 beers about 2 hours ago, and the defendant was observed to be unsteady on his feet. SFSTs were conducted, 6 out of 6 HGN, 4 out of 8 walk and turn, and 2 out of 4 one-leg stand. DIC was read, refused. Blood search warrant was executed. Blood was drawn. His license is available.
And any prior DWIs?
No, President.
All right, sir, I'm going to find that there's sufficient probable cause to go forward with your case. As a condition of your bond, you're ordered not to consume alcohol or illegal drugs. You will be tested. If I find that you're using, I will revoke your bond, put you in jail. No more PR bonds. Do you understand?
Yes, sir.
All right, we are going to reset your case to give you time to hire a lawyer. So I will have you go to Victoria, sign and reset. You'll get with Veronica for your bond conditions, and then we'll see you in a month.
I do have authority.
Are they who?
Shelby Burns.
Damn, just like.
He didn't sign off.
We don't have him right now, so he is not attached to your case. So we're going to reset your case, give you time. You need to maybe talk to him more so he can come back and file an attorney of record. But at this time, he hasn't claimed to represent you.
Okay.
So we will give you time though. So if you want to head on over, we'll have you sign a reset and then we'll have you get with Veronica for your bond conditions.
All right, Judge, top of 13, Lee.
Good morning, Mr. Lee. Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On May 8th in Harris County, officer conducted a consensual encounter at 7401 Colon Boulevard. Officer observed multiple no trespassing signs posted on the business property. Officer observed the defendant to be standing outside the location, leaning on a vehicle. Officer found the defendant had been trespassed from the location on May 5th, 3 days prior. The complaining witness, the manager at the location, stated that he told the defendant multiple times that he was trespassed from the location.
What was it?
Uh,
It was a convenience store?
let me double check it, Judge. That's what it sounded like. Yes.
Mr. Lee, I'm going to find that there's probable cause to go forward with your case. Just don't go back. That's the only thing I'm going to tell you, ask you to do. Just don't go back. Do you understand? Also, well, don't pick up any new criminal cases, but really, if you don't go back, all will be well. Do you have the ability to hire a lawyer? We will give you time. I'm going to have you go to Victoria, sign and reset. I'll have you take a seat while we get your bond conditions ready. Once you sign, at that point, you'll be free to go. All right? Please.
Gonzalez.
Hold on, Victoria. Let's get some of these guys out because
Okay, go ahead and sign here.
you want to call it all of them up. We'll get them out of all of them.
Okay, go ahead. Escobar.
I think there's one more. Yeah, look, come on.
Bottom of state city, O'Connell.
Mr. Otano, you're charged with reckless driving. You're facing up to 30 days in jail and or a $200 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 8th in Harris County, officer was conducting surveillance on a group of vehicles in a parking lot takeover. Officer observed the vehicle do donuts in a pit of around 40 to 50 people, getting within 5 to 10 feet of striking other people in the pit. Traffic stop was conducted on the motor vehicle when it left. Defendant was identified as the driver.
So he's doing donuts.
Yes, Judge.
Is he have a license to drive?
He does, Judge. I'm checking his eligibility.
Go. Sorry,
He had a license. I'm checking if it's eligible.
please.
As of right now, it is.
How old are you, Mr. Otano? You're 17. If I find that you drive like this again, I will put you in jail. I will deem you a public danger, and I'm going to make your bond extremely high. Do you understand me? You are not allowed to drive like this in any manner whatsoever. No reckless driving, donuts, street takeovers, racing. If you do, I will put you in jail, and then I will take your ability to drive away from you. They have been seizing and taking cars from people who participate in these types of actions. So if it happens again, you may very well lose whatever car that you're driving. You understand? What are you doing with yourself these days? Okay. Do you want to apply for a court-appointed lawyer, sir? Okay. Deputy Williams will give you an application. I'm going to have you sign a reset, then we will have you take a seat in the jury box. You will sign bond conditions. One more thing, you are not allowed to drive unless you have car insurance in your name. If you do not have it, then do not drive, and that is a condition of your bond as well. You understand? All right.
All right, the next is age 16, Perez. Come on up.
So no reckless driving, donut street takeover.
Yes,
You must drive with insurance. You said 17, right? Is that what you said?
Yes, bottom.
Mr. Perez, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir. Okay.
Officer observed a motor vehicle on I-45 appeared to be speeding above the posted speed limit of 65 miles an hour. Vehicle took an exit and then began speeding at 114 in a 50-mile-an-hour zone. Traffic stop was conducted. Driver was identified as the defendant. Defendant had a suspended license. Officer detected a strong odor of alcoholic beverage, thick tongue, speech, droopy and glossy eyes, and the defendant to be unsteady on his feet. SFSTs were conducted 6 out of 6 HGN, 4 out of 8 walk and turn, and 1 out of 4 one-leg stand. DIC was red. Defendant refused to provide a sample. Blood search form was executed and blood was drawn.
Tell me why it was suspended. Are there any prior DWIs?
Nope. No priors, Judge. Let me see what the action was for suspension.
Mr. Perez, I'm going to find that there's probable cause to go forward with your case. You speak English, correct?
Yeah.
I'm telling you now that if you drive, I will have a hearing as to whether I'm going to hold you in contempt, and I can slap you with 180 days in jail every time you drive. You will be signing a promise. This is an affidavit that you're going to promise to me today that you're not going to drive. I don't give a rat's ass what you have to do in this life. Do not drive. Do you understand?
It's for failure to appear.
You were ordered not to consume alcohol, illegal drugs, or unprescribed controlled medication, and you will be tested crazily to ensure that you're not using. You do. Likewise, into jail you go. This is not a revolving door. You pick up another case, you violate any condition, you endanger my community, I'm just going to put you in jail. make your bond high. You understand?
Yes, sir.
Do you have the ability to hire a lawyer?
Yes, sir.
We will give you time. I'm gonna have you go to, come up here, swear to us, you're not gonna drive. I'll have you sign a reset. You'll eventually meet with Veronica for your bond conditions, then we'll give you time.
Thank you, Your Honor.
All right, Judge, next is bottom of 18, Rogers.
114. Good morning, Mr. Rogers. Sir, you're charged with criminal trespass. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On May 9th in Harris County, officer dispatched to a home invasion call at an apartment complex. The complaining witness stated that he was in his garage with a witness and family when the defendant approached asking for a phone charger, but they stated he was going to keep the phone charger. The complainant told the defendant he could not keep it. The defendant then attempted to run into the complainant's residence. The complainant told the defendant to leave multiple times. The defendant refused. The defendant became aggressive and attempted to fight other people at the residence. The defendant attempted to then get inside the complainant's vehicle. The complainant continued to tell the defendant to leave. The defendant refused. The complainant stated that he does not know the defendant.
That's. You're very lucky you're not charged with a very serious felony case, Mr. Rogers. As a condition of your bond, you were ordered not to go back to this location. You were ordered not to consume alcohol or illegal drugs, and I'm going to test you within the next couple of days to make sure that you're not using. If you do, I will put you in jail. I don't know who you have in this life, but if I make your bond $20,000 to $30,000 and you don't have anyone to pony up that kind of money, you will be sucked like Chuck in our jail for who knows how damn long. It will take, and it usually takes about 9 months just to get a 911 call. You will sit in custody for a long time. Do you understand? You will get a monitor on your ankle and you're not to go into the 1,000 feet of where this person lives or works. No weapons. Like I said, any violations, in you go at a high bond. You know, I think it's probably prudent to put a what time of day or night was this? Was this in the middle of the night?
Uh, 11 p.m.
You have quite a bit of history in the last couple years. This happens at midnight. It's probably time for you to stop going out in the middle of the night, and you will now get a curfew. 9 p.m. to 6 a.m., you must be indoors. You violate that curfew, you know what's going to happen. Do you understand, Mr. Rogers? Do you need a court-appointed lawyer? Let me see if I have one on file already. I need you to fill out an application for me. Deputy Eshagon will give you an application. I'm going to have you meet, sign a reset. You'll get with Veronica for your bond conditions. Then we'll have you take your seat in the jury box.
All right, to top of 19, Ryan.
Yep. Mr. Ryan, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On February 6, 2026, in Harris County, officer dispatched an assault call at the Vanderbilt apartment complex. The complainant is a resident of the complex and stated that she's the defendant's ex-girlfriend and it was in a dating relationship for 4 years before ending it a month ago. The complainant stated she was arguing with the defendant about him urinating on the complainant's front door. The complainant then advised the defendant she was going to call law enforcement and assisting in his removal of him from the residence. The complainant stated the defendant then lunged at her, dragging her into the residence and started punching her in the head and face with a closed fist an unknown number of times. The complainant stated because of the assault, she had bruising in her face and a busted lip and felt pain from her injuries.
There are 3 other assault of family members with Mr. Ryan that are priors. Are any of these the same complaining witness?
They all are, Judge.
They all are. A 4th assault of a family member, all the same complaining witness. Mr. Ryan, look at me. I'm going to put a monitor on your ankle. If you go within 2,000 feet of where this person lives, works, breathes, I will deem you a public danger. I'm going to throw your butt in jail and I'm going to make your bond with many zeros by the end of it. Do you understand? Do not have contact with this person. Don't go anywhere near where they live, work, breathe. Do you understand?
But it's not true.
Stop. That's why we have trials and we will have a trial. But what I'm trying to do is prevent any further calamities. And the way that we do that are with bond conditions, keeping everyone away from everyone. Do you understand?
Yes, sir. We're dragging my bicycle all the time already.
This is not an argument. This is not a negotiation. You have picked up another assault of a family member. I'm telling you what the deal is. There are bond conditions. You either live to the conditions or you die with the conditions. I'm not asking much. All I want you to do is stay away from this person and don't have any weapons. I put a monitor to ensure that it don't happen or you don't go near. I'm not asking much. There is a protective order that has been issued in this case, and you need to get to know it. If you violate this protective order, the state can and probably will file a violation of the protective order, and that is the capital murder of misdemeanors. Don't violate the protective order. That means don't go where they live, don't have any weapons, don't have any contact, don't use third parties to attempt contact. Do you have the ability to hire a lawyer? We will give you time. I'm going to have you go to Victoria, sign a receipt. I will have you take a seat in the jury box. You will meet with Veronica for your bond conditions, and after that, you'll be free to go.
All right, Judge, top of 21, Samoy.
You say Savoy?
Savoy, S-A-M. O-Y-E. S-O.
There we go. All right. Good morning, sir. So you're charged with driving while your license is suspended. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On May 7th in Harris County, officer observed a vehicle without a rear license plate and conducted a traffic stop. Defendant was identified as the driver. Officer ran the defendant's driver license, which was found to be suspended.
Mr. Samoy, you're not allowed to drive. I don't care what you have to do in this life. You will be signing an affidavit with me today promising me you're not going to drive. If you do, I can have a contempt hearing every time you drive. You could be facing 180 days in jail and a $500 fine on a contempt charge. Do you understand? Just no. Don't drive. If you want to drive, go get a license, get insurance. If you come back to me and show me that you have it, I will happily take this restriction off. But until that point, do not drive. If you do not have car insurance and you get into an accident, someone else is going to be out of a lot of property and money, and that's not fair. Do you understand? This is why we do what we do, not to harm, hurt, to belittle. It's because it's fair for the other person. Do not drive. You have the ability to hire a lawyer.
No,
How do you support yourself?
work.
Okay.
Work in a restaurant. It's written position.
Deputy Etchigoin will give you an application. I need to know whether you qualify for an appointed lawyer. We just don't give them out like it's candy. You have to qualify, meaning that you are on the poverty level according to the federal guidelines. So what I'm going to have you do is Deputy Etchigoin will have you sign an application for an appointed lawyer. I'm going to have you come up here, swear test that you're not going to drive. I'm going to have you go to Victoria Center, reset, and then we'll have you take a seat in the jury box, sir. Please.
Okay.
All right, Judge, bottom of 13, Luther.
How are you?
Howdy, Tyler.
Morning, Judge.
Happy Friday, man.
Happy Friday.
You ready?
Like,
What's the thing? What's his last name?
Luther.
Come on up, Mr. Luther. Good morning, sir. So you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you, sir.
On May 9th in Harris County, officer observed a vehicle near the intersection of Milam and Preston travel northbound in a southbound one-way lane. Officer stopped the vehicle and observed the defendant in the driver's seat. Defendant stated he was coming from a bar where he had consumed alcohol, specifically 2 gin and tonics and 2 Modelo's. Officer detected a mild odor of alcoholic beverage, slurred speech, and glossy eyes. SFSTs were conducted 6 out of 6 HGN, 4 out of 8 walking turn, and 3 out of 4 117. The SC was read. Defendant provided the breath sample. Results were 0.07 and 0.072
You said that he was driving the wrong way
on a one-way.
on a one-way. Okay.
may I, you heard the solution?
Sure.
My client, works for Exxon. He lives in Baton Rouge. He was in town for training and was meeting some of the other people downtown. Wasn't familiar with downtown. We're not disputing the one-way street, but I do have a couple issues. One is the way that it reads is that the officer saw him driving down the one-way street and then pulled him over and then he pulled him out of the car. And then he didn't smell any odor of alcohol, or he didn't even, on the DIMS, he didn't state any signs of intoxication.
But he's allowed to pull someone out of the car. I mean, an officer anytime has the authority to pull him out for whatever reason, you know?
Then he was under the limit.
I get it, but that's not dispositive of in and of itself. I mean,
It's
when
not-
he pulls it, he smells the odor. What, tell me
Mild
what-
odor of alcohol, slurred speech, and glossy eyes.
So it's after, so the traffic stop is a 1/4 Amendment seizure, and then pulling him out of the car is a separate 4th Amendment seizure. That I think you need to have some reasonable suspicion for to pull him out for an investigating DWI, but you just pull him out as soon as it's done. Outside the scope, in my opinion, they're allowed to do.
And maybe for beyond a reasonable doubt, but for purposes of PC, it's a very low burden. And an officer is allowed to pull someone out.
Yeah.
Here, he pulls him out, he sees slurred speech, or he hears slurred speech, there's an odor of alcohol. And I think that there's enough to go forward, sir. Beyond a reasonable doubt is a different standard in and of itself, but for purposes of probable cause, I'm going to find that there's probable cause to go forward, Mr. Luther. As a condition of your bond, I'm ordering you not to consume alcohol, illegal drugs, or unprescribed controlled medication. You are not allowed to drive unless you have a valid Texas driver license and liability insurance. You say he's out of town?
He lives in Baton Rouge.
Okay, as long as you have a valid license, including a Louisiana license, great. But you also need liability insurance. If you don't have car insurance in your name, do not drive. And just don't use alcohol, don't use illegal drugs. You're going to get tested. Don't drive unless you have those 2 documents, and then you're fine.
And just, he's being tested by Exxon. They're extremely strict. My wife worked there for 7 years.
I get it, but I don't know. If he gets called upon, he'll have to go to a Quest diagnostic. if he's over there, because I know that quest is legitimate, you're not allowed to go to Punka City, buy a test. It has to be a quest, so we know that it's legitimate. Get it to him. It's your responsibility. Usually when we call someone to test or to come downtown, they go to pretrial services and then we pay for the test, so it doesn't come out of your pocket. But here, I can't pay for it. So you'll be expected to go to the quest, get the test done, get it to Tyler, he'll get it to us, and then everybody's happy. Do you understand? All right, we'll have you sign a reset. You'll,
Ponca City, is that a real place?
not, well, that's what my dad used to tell me, so I don't,
All right, thank you.
maybe. Bye, Tyler.
Okay, thank you.
Happy Friday, please.
Judge, bottom of 7, Flores. I can just sign.
Dang, another reckless driving. Hey, can you spit the gum out? I'm chewing like he's a small farm animal. Mr. Flores, you're charged with reckless driving. You're facing up to 30 days in jail and or a $200 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you.
On May 9th in Harris County, officer conducted the traffic stop on a motor vehicle after observing it do donuts in a parking lot of a Family Dollar store. Plainclothes officer at that meetup in the parking lot observed the motor vehicle in a pit doing donuts, getting within 5 to 10 feet of striking others and vehicles. The traffic stop was conducted and the driver defendant was identified by Honda and passport.
Sir, I'm going to find that there's enough probable cause to go forward with your case. You do not have a Texas driver's license. You are not allowed to drive. I don't care what you have to do in this life. You will be signing an affidavit with me today promising me that you're not going to drive. If you do, I will put you in jail. I don't care what your excuse is. I don't know what your immigration status is, but if you're not in this country with permission and you go to jail and immigration finds you, they may very well put a detainer on you and you will be in custody for a long time. Do you understand?
Yes, sir.
I'm going to have you come up here. You're going to promise to me and sign an affidavit that you swear you're not going to drive. Do not drive. Because you have a lawyer, I will waive your appearance. It is your responsibility to stay in touch with them and they'll tell you if and when you have to come back to court. If they tell me they cannot get a hold of you, then likewise, I will revoke your bond. So for now, we will have you come up, swear to us that you're not going to drive. I'll have you sign a reset and then we'll have you take a seat while we get your bond conditions. Thank you.
It states bond conditions.
Yeah, no driving.
Yes, ma'am.
Yeah, I'm good. This is fine.
All right, Judge, thank
You can just get it out.
We're running out of room. Do you want to get some people out first? Lee coming up. Up to the, we're gonna have you sign, get you out of here. Lee, get him out. And then, oh, thank you. Hey. Thank you.
Yes, yes, it's signed off. Bottom of 21, Stewart. Come on up.
Look.
Villarreal.
Damn, is that the same one? Good morning, Ms. Stewart. Ma'am, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, ma'am.
On May 8th in Harris County, officer spoke with the complaining witness who observed the defendant enter the Walmart and began placing trading cards into a shopping cart. Defendant then walked to the auto department and transferred the trading cards into her purse. Officer detained her after passing all points of sale without making any attempt to pay for the items. Defendant admitted to concealing the cards in her purse for a total of $511.47.
Ms. Stewart, I'm going to find that there's probable cause to go forward with your case. As a condition, you're not allowed to go to any Walmart for any reason. You understand?
Yes, sir.
If I find that you do, or if you pick up a new case, I will revoke your bond, put you in jail. No more PR bonds. This is not a revolving door. Do you have the ability to hire a lawyer?
I'm not sure yet, like right now, like I'm on like a stable job, like I have like
Are you working at this time?
I do kind of like a side gig type of thing, so I guess not like consistent income. So, you know, I'm texting, writing things around, if I could. I guess file the form to see if I qualify for.
Sure. Deputy Williams will give you an application. I need to know everything, whether you're married, other income that you have coming in, boyfriend, whatever it may be, just all it's household income. So whoever you live with, all that income needs to be reported, and then I'll take a look to see whether you qualify.
Okay.
Deputy Williams will give you the application. I'm going to have you sign a reset. We'll have you take a seat in the jury box. Do not leave until you sign our bond conditions, man.
Okay.
All right.
Thank you.
All right, Judge, next is top of 22, Taylor.
No Walmart.
Already
Please. Thanks. Ms. Taylor, you're charged with criminal mischief. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you.
On May 3rd in Harris County, complaining witness stated the defendant arrived at the residence and damaged both side mirrors of his vehicle. Complainant personally observed and immediately recognized the defendant as the individual responsible for the damage. Defendant used a Yeti style cup to strike and break both side mirrors. Cost to replace it is $400 each, totaling $800. Complainant stated the defendant has a pattern of conduct, including driving by his residence, waiting outside, and previously entering his vehicle without permission.
What conditions should we place other than obvious no contact? Anything else you think? Ms. Taylor, I'm going to find that there's probable cause to go forward with your case. There are a multitude of ways that we can ensure that you don't go near this person, including a GPS monitor that is huge, clunky, and extremely embarrassing to put on your ankle. I'm ordering you not to go near this person's house, not to go what street they live on, where they work. You violate this. First, I'm going to put you in jail, and then I'm going to put that monitor on your ankle. I will give you the benefit of the doubt now, But when I mean no contact, I mean no contact of any kind. Social media, phone calls, text messages, use of third parties, going near where they live, where they work, nothing. Do you understand? It's a yes or no.
Yeah, no, I do,
Okay.
I do. I just, can I ask you a question?
You need a lawyer. Unfortunately, everything you say here, they're sitting it down, they're gonna sit there, they're gonna type to prove your guilt. So what, it just, these are the normal course of things. Whenever you pick up a criminal case and there's an alleged complaining witness, the idea is to keep everybody away at all times so that nothing should further happen in the future. Do you have the ability to hire a lawyer?
Yes,
We will give you time. I'm gonna have you go to Victoria, sign a reset. We'll have you take a seat while we get your bond conditions. Once you sign them, at that point, you'll be free to go. Would you please do me a favor and let the complaining witness know of what we have ordered
Yes, sir.
so that in the event that she tries, we can.
Yes.
Thanks.
All right, Judge, next is page 23, Williams. All right. so this is like- Okay, thank you.
Is Kara Williams?
Yes, Judge. Both cases are new. One just got put on for the 18th instead of today.
You're on bond for criminal mischief. You pick up an assault and now you've picked up a robbery. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On the assault, Judge? Or on the criminal?
Both,
Okay.
all three.
Okay. Starting with the criminal mischief charge, Judge. Complaining witness is the ex-boyfriend. On August 8th, 2025, officers dispatched to a home in Harris County, spoke with the complaining witness who advised that he was at his friend's house when the defendant came over, got angry with him being there, and then walked outside and slashed 2 of his tires for a value of $700. The witness on scene confirmed the complainant's story.
Okay.
The assault charge, Judge. Same complaining witness. On September 27th, officers dispatched to a residence and met with the complainant and the witness. Complainant advised that the defendant, his ex-girlfriend, had come by the residence earlier and began causing problems. That she was upset because she has a pending case against her and believes it was because he called the cops on her previously. The argument escalated to be physical when she punched him in the face and then pushed him over a table, causing him to fall. While he was on the ground, she got on top of him and grabbed him by his hair and struck him multiple times with her other hand. Complainant advised he felt pain.
Okay. Robbery, please.
This one's the robbery charge, states that it's in the 179. It is,
Tell me, do we have a trifecta, the same complaining witness on the robbery as well?
no, Judge, different person on the robbery. May 8th, 2026, officer dispatched to a food mart in Harris County for a robbery call. Officer met with the complainant and observed the defendant to be on the scene. Defendant matched description, fled on foot but was detained at the front of the store when she saw the officers. Defendant Williams was detained in front of the store. And she was Mirandized and gave her statement that she helped a co-defendant kick the complaining witness out of the store because he asked her to. Complaining witness said that after a verbal altercation, the co-defendant and the defendant, they threw the complainant out of the store into the ground, kicked her and punched her, causing pain and fear for her life. Complainant said the third unidentified male reached in his back pocket, patted the complaining witness down. Defendant, co-defendant took the complaining witness's phone from her hand during the attack, and the unidentified co-defendant told the complaining witness to give him $100 and password to the phone, or to give the phone back to her. Officers recovered the phone on scene, hidden in the food store.
Miss Williams, this is not a revolving door. At some point, there are just no more PR bonds available for you. They gave you a PR bond on the criminal mischief. I'm not. No, no. You are a danger to, I can't give you another PR bond. It's just not going to happen. I'm going to revoke it. She's going to go with you. As a condition of your bond, you will wear a GPS monitor. You are not to have any contact with the complaining witness in this case at all. No weapons, and you will have a monitor on your ankle. So I know that you're not having contact. You're not to go within 1,000 feet of where this person lives or works. Do you understand? Do you see a protective order that's been issued in the, I don't. Let me see. I'm entering now what's called a mattress order for emergency protection that identifies Mr. Williams as a protected individual. You cannot commit family violence or an assault against this person, commit an act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harass behavior. You cannot go within 1,000 feet of where this person lives or work. Do you understand? You violate this, they may very well file yet a fourth case on you, a violation of protective order, and it just only gets worse. No contact means no contact. Do you understand? Okay. We're gonna, hey, and then Deputy Williams also for the moment. Yeah.
That's it for now.
Wonderful. Hey, you ready? Come on. Hi, Mr. Bonds.
Hey, I had Mr. Herrera, we're gonna do the plea. He submitted a paperwork. He didn't complete pretrial intervention.
They kick him out.
Yeah.
Okay, are you ready?
Huh?
Are you ready?
Yeah, and you know, as far as the court's concerned, he's done jail time because you were.
Yeah, I'm usually on the first. I'm okay with back time.
Oh, then, okay.
Yeah,
Mr.
well, we
Herrera.
need him to come thumbprint. James, he's signed everything?
Yes.
Okay, great. We just need him to do a thumbprint and then.
Yes.
So
They're gonna use it.
Mr. Herrera, you're charged with driving while intoxicated, you know? You may not today, may not be tomorrow, maybe not next year, but at some point you're going to kick yourself because you had the opportunity to have this DWI dismissed. And now, because of your failure to complete the intervention program, it will now go on your record. It will be there for the rest of your life. You will now forevermore be facing a minimum of 30 days in jail. No more proverbial slaps on the wrist. Do you understand? You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you accept this agreement and once you plead guilty, it goes on your record. You'll never be able to take it off. You understand?
Yes, sir.
How do you plead to this offense? Guilty or not guilty? I'm going to find you guilty. I'm going to follow this agreement. I'm now going to suspend your license for 180 days. Do not drive until you get a license. And good luck to you, sir. And then we'll waive the fee.
Okay.
Hey.
We don't, that was the case from.
Sure.
So, I spoke with Ron, it looks like for whatever reason, she talked several months.
Take it downstairs.
Oh,
For,
really?
this, yeah, it's 500. One of them actually told me they want to make, they just want to make money, so they want to work with her.
They want to make money, so they don't want to work with her?
Because they wouldn't make money. Okay.
Well, I mean, they're in business, right?
You know,
But how much?
so the bond we set was at 500. And
Sure.
when we set the bond, we assumed that she would pay, you know, the 10, 20% or whatever it is. Every bond that she's talked to now has said that she's just gonna have to do, you know, 100%. So if we were banking on her getting
I'm not giving her a $50 bond.
$100 bond, because she's gonna have to pay the full amount. You know, and I'm happy to get her on her phone to.
What do you think?
That's her.
Can I get your problem? You sent it.
Oh.
Sure. I figure if that's the amount of money she was gonna put up anyway.
Hey, Martin, I see you. I saw Miss Green here. Yeah, we'll do it.
We're ready to go on.
Yeah, we'll do it next.
I don't get on phones or.
Well, I gotta get, what are they? I mean, what are they?
Stay with the opposers, because the second offense.
Well, it's really a third.
Need more reason.
But, so what's reasonable though? You know, the reason is they offered her
Yes.
the program.
She's not even gonna get out today. She was gonna get out on Monday. She's got the monitor. There's no way they're gonna process her out. Before Monday.
What's a reasonable amount? What do you think? Because of all the flight that she has, and you need to advise her this, like, because of all the times that you have forfeited.
We've spoken to her extensively.
Oh, okay.
State, we'd be fine coming down to 250, splitting it.
All right. So you want 100, he wants 250. Let's split the baby. 150.
Okay.
Yeah.
Thanks, Josh.
Do you, can I have the cause number?
Yes,
Please?
Judge, it's 258,
Okay.
2517.
Did you see one? Did you get it? 258, 2517. We're gonna do a further bond reduction to
I will let her know.
150. But that's it, man. Sebastian, that's, all right. Are you ready? Ms. Green, coming up. So they're dismissing the assault. right?
Yes, sir.
Ms. Green, you have worked out an amazing deal. They're going to dismiss the assault in exchange for your plea on the failure to ID. Not many times in life that you're going to get such, you understand? You are giving up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. Once you plead guilty to this offense, it will stay like this forever. Now, you need to understand, this is a Class A misdemeanor. So if you pick up another one, you will be looking at a minimum of 90 days in jail. Do you understand?
Yes.
How do you plead to the offense, man? Guilty or not guilty?
Yes.
I'm going to find you guilty. I will follow the agreement, sentence you to it. And good luck to you.
Thank you, Your Honor. Maybe.
Thanks. You got it. Thanks, Martin.
Are we?
You too?
That will be your.
Kobe, ready?
Yeah.
Hey, bud.
Morning.
Good morning.
Mr. Demetria Murphy, I'd like you here, bond violation.
Again.
So it's from the drug test that you said before, last time we were here. Good news, said no problems on her scram, no alcohol.
She's still testing positive though.
I understand. It was, it's like it was sort of type code, a couple of pain pills, just let you know.
Does she have a prescription? Miss Murphy, come up.
Now that I know.
Regional services does not receive.
Okay, well, hold on, Miss Murphy. Or come on up.
We'll tell you that she did
Take a seat.
test today, drug test today, it was negative.
I understand that, but that's not the problem. You know, it can't continue. At some point, we have to say when. It's a violation after violation. And the problem is that if I let you go now, I'm telling you, it's okay for you to continue to have bond violations. And it's not. At some point, we have to say enough is enough. Do you understand? Okay. Sorry. Look in your bond.
So you know, the first bond violation was just from state death, or this is the first substance. So you,
But-
I understand, but
When my child keeps telling me, I'm sorry, Dad, I'm sorry, Dad, I'm sorry, Dad. The sorries at some point have no value. Do you understand? Okay. Let's talk about a bond.
sorry.
Let's talk about a bond. What do you think? What's reasonable in light? What do you want? Reasonable.
You're into 2,500.
We'll split 1,501. All right. But hey, tell her it's no tolerance. Further on? Yeah. Okay, my friend.
Maybe there's like a Spanish, maybe?
Yeah.
Yeah.
Yeah, yeah, stole my car, sure, and they snorted me for $400.
Doris Anderson.
Sit down. He can't leave.
He was coming to sign.
Oh, okay. All right. Hey, are you ready? Hi. Oh, you got this, gentleman? Okay. Happy Friday. How are you?
Doing pretty good.
Oh, this is the one from yesterday, right?
Yes.
We're talking about? Good morning. Good morning, Mr. Guerrero.
Good morning.
So you're charged with terrorist threat. You're facing up to 6 months in jail and or a $2,000 fine. You have worked out an agreement. They're offering you 25 days in jail with the credit that you received. I think it's what?
7 days.
Really? Wow.
9
days credit, Judge.
That's even more of a wow. You were giving up a lot of rights by entering into this agreement, Mr. Guerrero. You give up the right to a trial, right to compel witnesses to testify on behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You also give up the right to appeal. Once you plead guilty, this will go on your records. You can never take it off. Is this what you want to do?
Yes, sir.
You need to understand that from now on, you're facing a minimum of 30 days in jail for any new cases, at least 30 days. All right? All right, sir, I'm going to find you guilty. I'll follow it. Good luck to you, sir. Thanks.
Thank you.
Mr. Brown. You got it. Have a wonderful weekend.
You too. Thanks.
Mr. Bernardi, again, another BBR.
We worked out a plea with the state, Your Honor.
Tell me.
Time served.
Oh. Okay. Mr. Riley, you're charged with criminal trespass. You're facing up to 6 months in jail and or $2,000 fine. The agreement that you have worked out is 2 days in jail with credit for the 2 days that you've done. You need to understand that this charge will go on your record. It will be there forever. You understand? You're now on, will be facing a minimum of 30 days in jail for any new cases that you pick up. Do you understand? You're giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you are not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So this is final today. You can never change this. Is this what you want to do? How do you plead to the offense? Guilty or not guilty? I'm going to find you guilty. I'll follow the agreement. Good luck to you, sir. Thank you, Mr. Bernard. I've got Kavita. Yeah.
Page 30, Judge. Tom, 32.
Good morning, Kavita.
Morning, Judge. Took me a minute to find my unmute
Hi.
button. How are you?
Happy Friday.
Happy Friday. I just have one with you in the holdover. Danny James.
Yes, ma'am.
Mr. James, we have a plea agreement in felony court to do probation. So I can iron out the details to see if felony will dismiss the misdemeanor once he pleads on the injury. Or
You want to
if
set it for after the felony?
that'll work, Judge. I think he has a TRAS on June 10th. Judge Jones won't do a plea until after the TRAS, so I think we're June 15th. So June 16th would be fine.
Yeah, okay. Done.
Okay. Thank
Okay,
you.
have a great Friday.
You too, Judge.
Bye.
Bye.
This way.
Victoria. In the talks, he's kind of. What you like, scarf, black and white scarf. Okay, thanks. Stop, or I will put you in back. You've already been warned twice. Do you understand? Miss Stewart, come up. I mean, really. You were just now telling me that you work, that you do have some income, and yet you put zeros in everything. Stop. I will send you home with an application, and I want you to be truthful. When you come back, I want you to do everything that you can, be honest on this application. This is a sworn document that is perjurous if you lie and can be a potential felony offense. Do you understand? It's not a joke. Please. She signed her, make sure she signs her bond conditions.
Thank you.
Good morning, Mr. Gerard.
Good morning, Mr. Fleischer. You look nice this morning.
Oh, thank you. I appreciate that. Give me 1 second.
Yes.
Hello? 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 All right, so Mr. Gerard, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. You've worked out an agreement. They're offering you 21 days in jail with credit for the 7 days that you've done. You need to understand that this will now reflect as a conviction on your record. I don't know how many thefts you have, but if you continue to pick it up, at some point, they may hit you with a felony. A third theft is a felony offense and you're looking years instead of days. You understand?
Yes.
You are giving up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization. You give up the right to appeal. So this is final today. You can never change this.
Yes.
Is this what you want to do?
Yes.
How do you plead to the theft? Guilty or not guilty?
Yes.
I'm going to find you guilty and it looks like the other case is going to be dismissed, right? All right.
Thanks.
All right. Good luck, Mr. Gerard. Take care,
Mr. Fleischer. You keep up the great work.
Violent dismissal now.
Thank you so much.
Yeah, it's not, you basically hear. Oh. Okay. Yes. Okay.
Yes, sir.
Stewart, Caitlin. Is that everyone? You can make sure that from this one, I don't let them go back there. Okay. This.
What's going to be
And these are your bonds.
Taylor Ali.
Oh,
But my dad was. And, you later.
They,
Oh, where'd you go to Boston?
Baylor.
Didn't know if you.
Yeah. I went to undergrad in St. Louis University.
When you trained.
Oh, yeah. My grandma was coach for Cherokee.
Oh, yeah. Cool. What do you got? That's not.
No, I do. There's conditions are.
Jason didn't want to take.
So bad.
When we had it.
It's just so like, I was thinking.
That'd be great.
I mean, there's so many other things that would happen in my face.
Yeah. What is some food soccer things one others. And then we got that. It has been pretty good.
Where did they play?
SAFC, it's always on the Stars. Complex. It was like 30 guys.
Okay.
Yeah.
Okay.
They did, we're supposed to get from them that last, and then the MLS gave me straight to the office. They also had these. Yeah, you know. Yes, nobody's talking, no big soccer, basketball, so. Got the US. The
They're talking about still. Of course, and so I knew this going to. They're saying.
Oh, yeah.
And they're like, house control.
I mean,
They're.
for the armory.
Yeah.
I said, shit, so, you know, there's. If you ask questions, there's I'm going to do their else.
Being part of that, so they for office. So what I'm going to see, this is in the conversation. Here, has to work for you. So 7 year old.
Well, and then finally show up. Well, yes,
Oh,
but then judge.
Yeah.
Yeah. Yeah. I think that's just. That's what I like about this. When you're out of this, once you cross 9 in a row.
Yeah.
So then that.
Well, we'll have to do it. Yeah, so.
Get rid of. They're not. But they actually did.
So that's that in back the clock, that is an issue for the message.
This.
This way.
Yes, if we're open.
Are they, I haven't kept track of them.
This is only better, but almost.
But it's still bad.
Yeah.
Really have to be fixed.
I'm always.
Yeah.
Yeah. So it's, yeah, so it's, pretty recorded.
Any questions about your?
No more? No, 4 months on Sean, I didn't have to, I made it today, in July 14th. And then after.
You didn't have statement.
There's a lot of reading.
One side. Yes. Silent discussion.
One second.
All right. Yeah. Good morning. Yeah.
Yes.
I'm probably.
What's the deal? Take one.
Who's on?
Why is it so hot? Like, is it hot?
Yes.
Oh, you got a jacket on. No. Yeah. All right, where we at?
We still have several open doors.
Okay.
Yeah.
Sean,
That's why.
Okay. Yes, yes, right.
Good morning, Judge.
Hey, what's up, Mr. Payne? How are you?
Oh, yeah, I can see it in there. They do a little bit.
You know, I from San Antonio.
Yeah.
Thursday.
No, see. Yeah, I'm moving from. You can't do it.
You will go honking after.
Yeah.
I had a condo that was good. She like, you give us something that happened to start on the game. No, he said. I was like, well, we're closed. Honestly, it's not bad. It's in club, but like, it's not a lot.
So we're gonna find something. Miss Taylor?
Do you want to go through the list so far? Hey, be efficient, dude.
Me? You tell me that. I'm efficient.
My name is Bennett and I ain't in it.
Okay. I like your chicken.
They're not mine. I don't know who they are.
Really?
Correct. I don't know. Someone else does it. I don't.
I saw you look at it. It's getting early. Okay. Okay, thank you so much. Have a great day.
Take care. Oh, Greg, I saw Greg. What happened? Did you no show it again? Oh, they dismissed. Okay. On that no PC case,
Yes, Judge, the DWI?
yeah, you reset it. Did you can dismiss? Reset it. Okay. No, yeah.
Okay.
No, no. Bottom of page 5, I guess, huh?
Yes, Judge. And top of the stairs.
2501 on DeLorean. Oh, yeah, got it. Yeah.
Top of 5 is supposed to approach. T-Rex is 5. I think the one about that.
Oh, Darla's here. Darla.
Oh, okay. Top of 5.
Yes,
Darla,
Judge. Yes,
I'm
Judge.
sorry, I totally forgot about you. Next time, just yell so I don't forget, you know?
That's fine. I was just listening.
Wait. Oh, hell no. The case is 207 days old. You reset it for a month? No, 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 no.
No. Judge, you reset it for us to get a TRAS. I submitted the request. That's the date we
Yeah,
got.
yeah, but sooner than a month. You're
Yeah.
200 days. So I don't,
I'm in
pick a day
agreement.
next week. I don't care, whatever you want.
So I just told my client, pick a day that we can come in and we
Well,
come in.
let us know so we can reset it for that day. Have him come in and we'll send him for a walkthrough TRAS and then we'll give you another couple weeks to finish everything up. But I don't want to, you're 207 days. We're going to set it for another month.
Yeah,
A
I
month and
didn't
a
pick
half.
that TRAS date, so I'm perfectly fine with that, Judge.
Yeah, whatever you want. I don't care.
Okay. You want me to give it to you now?
Sure.
Okay.
I way to be
The
efficient.
21st, May 21st.
Okay, so just let him
Perfect.
know to be, or him or her.
It's a guy.
Yeah, so let him know to be here. The earlier he gets here, the sooner we can send him for the TRAS. If he gets here first thing in the morning, we'll send him first thing in the morning. The sooner he gets here, the sooner he'll get through, so there's no line of other people, you know?
Sounds good.
And then after that, just pop in again and we'll give you another 2 to 3 weeks to finish everything up after that.
Perfect.
Okay?
Thank you.
Okay, have fun.
You too.
Page 10, bottom of 10, top of 11.
No show? Uh, 25, 5,002 on both. And then I got to do a bail order. Hey, is Shatori, is there a day that you don't like walkthroughs on or that you can't? Are you good with any? Yes? Okay.
It's the last Thursday of the month, they normally share all status.
Just, you'll have to remind me, so I don't, yeah.
Any days.
I'm gonna leave it. I'll leave it.
Leave it as.
But just no more PR. I mean, really.
That's so pretty.
All right. And I'm definitely doing this referral.
Thank you for that. Yeah.
Okay. Hi, Miss Finley. Happy Friday.
Oh, thank you. I see her.
Did you guys dismiss Owen? It's a PTI. Looks like, is it ready to be dismissed? Yeah,
Yeah, all right, I thought.
you did? Okay.
All right.
Jeff, how much did you vote, bottom of 14 for?
1501. And then they're gonna dismiss Owen, top of 16, top of page 17, 2501. Top of page 20, 2501. I'm assuming right underneath it, same thing. 2501.
24.
What? Oh, I guess Val's client never came, huh?
That's what this is?
No,
Oh, no, yeah, that was.
If you- we never, okay. 5,002 on. What you talk about, Willis?
Oh, well, then it'll go like this.
I know.
I just missed the GPS, that's all.
Mr. Savoy?
Ms. Mogadisian, you ready? Are you ready? No? Oh, okay. Yeah, take your time. Of course. You don't have to ask, just come. It's okay. No, we're not gonna do it at this time, but we advise her that if we get wind that anything should happen at that point, we'll first jail, then it goes on. So not now, just no contact, no weapons. Yeah.
Oh, I did put a.
Sure. Got it. On her, Ms. Taylor? Got it. Okay.
Oh, yeah. Yes. Yeah, you're free to go see those. But you're free to
Oh, where are the conditions? Okay, got it. Hey, on Taylor, it's in regular published. I can't uninstall it for some reason. You guys need to do something. Right.
That's the, condition.
Yeah, we're not, they're, yeah, please. No, because I think that there was a miscommunication, so we don't need to do those conditions. Yeah, okay, yeah, just do that, that's fine.
Good morning, Jed.
Hey, come on up. Good morning.
Okay, so I am here, on a Mr. Williams, who's, I guess, Mr. Reese taking in.
Yep.
So I'm trying to understand, Jed, what's, why?
She's picked up 3 successive cases. At some point, we can't continue to give her,
Well, but I think the issue here is, Judge, from the 2 misdemeanors that, they were 2B, so she was never taken in. She was taken in on the misdemeanor on the day that she was arrested for the felony. So everything happened on the same day. So it wasn't like she had a PR bond, she was out. She never had a PR bond. She was only given a PR bond the day after she picked up the robbery because she had dealt with over 2 meetings.
but they didn't all happen on the same day.
They did. No.
They did not.
No, the misdemeanors were 2B, so they happened.
I get it, right,
So.
right, but
But she never had a PR bond. There was warrants,
I understand.
which she was unaware of.
But I think that she's a danger to the community. Has 3 to 4 different victims. She picked up 3 cases, one of them being a serious robbery. And I don't know if it's a good idea to just,
Well, I guess the issue is she actually posted bonds. At least a bond.
I'm not touching her surety bond. I'm not touching anything else. I'm just not gonna, and I'm leaving the bond at $100. I'm just not gonna give her a PR bond.
Okay.
I just don't think it's a good idea what conditions can we place that will protect the community?
Well, I think because she actually posted bond in the felony case, then we could mirror the felony bond. And because she actually posted a bond for that.
The only condition that they really put on there is don't go back to the food mart. She's charged with a robbery. The only condition other than no firearms is just don't go back to this place. It's a robbery case. And the only thing they did was put no going back.
Well, so then.
And she has a mischief, an assault, 2 of the same complaining witnesses, and now a robbery. Clearly, she's a danger to the community. What can we do to protect the community?
Well, we could definitely put a conditional, obviously, that's the only condition for the felony, and obviously, the first condition would be obviously no communication with the complaining witnesses, which I don't know why that was not a part of the felony bond. So we could definitely have no communication with the complaining witness, for those, yeah.
I don't want her to get the appearance that this is a revolving door. That's what I don't want. You know, I don't want her to think, hey, I could just continue to pick up 3 cases and I'm just gonna walk out of jail. Just no problems, no conditions, just don't do anything. And that's what it seems like, you know? And at what point?
Well, I guess, I understand at what point, but I guess my point is, this is like the starting point, because she never was, because she had a 2B, so she never actually got an opportunity to come to court and show the court that she would be able to comply. These cases probably would have been over if she had got picked up at some point in time when she had but because they were 2Bs, this is like the starting point. It's not, so I think at what point will probably come later. This is like the starting point. She just got arrested on all these cases on the same day.
What do you think?
I'd be opposed just because of the facts of the AFM. She acknowledges that she has a pending case open, and that's why she goes and assaults the complaining witness in that case. So I think that she knew, to your point, about the case that was pending and then still committed allegedly the second offense of.
Tell me that, because I didn't know about that.
So she was upset because she had a pending case against her and believes it's because he, the complaining witness, called.
I'm not giving her a PR bond. It's not gonna happen. She knew, it's just not gonna happen.
That's the assault family member.
Okay. Well,
I'll leave the bond as is at $100.
I think there's something that he's giving me a false perception of. What he's referring to is the old case, the previous case that she had 2Bs on, not the robbery case.
I know.
What he's referring to-
I'm talking to referring to the criminal mission. Yes, I understand.
No, I guess my point is, he was trying to give the perception that she knew about the warrants, so that's when she committed the robbery.
No,
Okay, so
the assault.
the assault.
Has an open warrant for a criminal mischief on this person where the alleged tires are slashed. Goes up to him, knows that the mischief is open, and as a result, allegedly beats the living.
I understand. No, I understand. I understand. I was.
Let her know, please. It's not a revolving door. And I have also, we're not out for blood. Otherwise, I'd set her bond at $10,000, $20,000. I'm leaving it $100, but I want her to understand it's not a revolving door. You know what's going on, yet, number one, you evade. Number two, you pick up an assault, and then now a freaking robbery. Really?
Understood.
Yeah. Okay, I'll leave it as is. So, hey, I have put GPS prior to release, no contact, no weapons, no drugs, no alcohol, and then so she doesn't have any contact with this person, please.
Yeah. I let her know, Trish.
Okay,
Thanks, sir.
thanks.
Yes, sir.
You ready? Yes.
Crockett and the doctor, he's in the jury box.
Come up, Mr. Crawford
Crockett.
or Crockett, bring your stuff.
Your Honor, his wife is in the audience as well.
We'll do probable cause first. I'm not going to do anything until we do probable cause. Mr. Crockett, where did you think you're coming? To the beach? Huh? Is this an appropriate way to dress? You're going to a criminal court. You're not going to the beach. You're not going to hang out with your friends. This is not about, you're coming to court. You're now stand charged with another case. You're charged with assault. You're facing up to a year in jail. and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On May 9th in Harris County, officer dispatched to a Family Dollar store regarding a disturbance call. Officer observed the complaining witness lying on the ground, bleeding from the mouth. A witness, a coworker, showed video footage of a male who witness advised assaulted the complaining witness. Officer reviewed the video, which showed the complaining witness standing at the door, the defendant to get in his face, complainant push him away, and then defendant striking the complainant twice, causing him to fall to the ground. A citizen advised the officer that the defendant was walking northbound to the store. Officer observed the defendant matching the description of the male in the store video. Defendant was detained. Complainant advised that the defendant struck him with a closed fist on the right and left sides of his face, causing him to fall and lose consciousness.
Wow. Lost consciousness.
Yes, Judge. Complaining witness advised that he believes his arm was broken and he was in extreme pain.
Is there a broken arm? I think you need to follow up. That's some serious injury.
Yes, Judge.
Mr. Crockett, I'm going to find that there's probable cause to go forward with your case. The only thing I told you not to do was pick up a new case. The tears that you shed now are probably the same. I am now revoking your bond.
Before you revoke his bond, and I'd like to address what he's wearing at work today. He was homeless and these are the only clothes that he owns. If he has other clothes, he would dress more appropriately. And he's crying because he's worried about his kids and his wife who's here and who's gonna protect them once he's not there. His wife was here at this incident at the dollar store when, as it says later on in the DIMS, before the state finished reading, that Mr. Crockett said so himself that he was pushed first. And he was harassed by the employee and was defending his wife.
You said there's video on this?
That's what they didn't say, Your Honor, yes.
We will get the video. Mr. Crockett, you picked up a new case. And the guy, or was it a guy or a girl?
I believe it was a male, Judge.
Lost consciousness. You always have the ability to go and walk away. No one forces you to do anything in this life. You can walk away. You're the one that's on bond, and I advise you when you get here, I'm going to protect my community at all costs. And if I have to throw your ass in there because you were a danger to it, then that's what I'm going to do. But it's unacceptable that you are on bond and you picked up a new case. If you have kids, if you have a wife, this is what you think about before you allegedly lose self-control. You will now go to jail. Goes with you. Perhaps now we will get your attention. The bond is set at $100 in the assault. I will leave that as is, but due to the violent nature, I'm going to now set your bond on the trespass at $5,001. If you do get out, you will get a monitor and you're not to go anywhere near this store or near the complaining witness or not to have in possession of any weapons. And let me tell you, if you do get out and you pick up a third case, I'm going to go bananas on all of your bonds. Do you understand? Thank you.
Judge, what's the new bond amount?
5,001.
And that's only on the criminal trespass?
Yes, ma'am.
I think that was really awesome.
Hey, can I send them? Can they go?
Judge, yeah, they're not Spanish speakers.
Guys, we're done. Go. Have fun. Have a great weekend. I'm sorry, did you?
Yeah, I was just, no, I was saying we had a time.
No,
No.
the first one.
Gotcha.
The mischief. I'll do a bail. I was about to do a bail now, so leave the bond as is, just no PR.
Okay.
We have two Spanish, Terry never showed up on, so I just.
Say it again?
Terry.
Terry, who?
Spanish. Terry.
Oh, really? That's weird. He's usually pretty good. Did you reach out to him?
Yes, multiple times. I sent him several emails and I just now at 11:30 asked him to reapply.
Okay,
Because
all
he
right.
got one of the ones first thing this time.
Who is the jail?
Bomia. Ditch 25.
Okay, he's got an ice hold and he's got a 10,000 on a felony evading. So. Who is the other one?
Signed.
Oh, Miss Science. Okay, so I think all right, we're done.